It is August 11th of 2026, and this is the court gallery. We kick things off in Judge Simpson's civil docket, where he has to untangle a deeply frustrating landlord dispute over missing money orders and locked payment portals. We'll also get a follow-up on a red tag property owned by a masked landlord who is sure her previous tenant is out to destroy the rental property, and she might be right. Then we switch to Judge Middleton's courtroom, where a defendant's creative choice of a downtown flower bed as a bathroom earns some swift consequences. After that, a custody dispute escalates into a drunken altercation with a brick, and we close things with a suspect who tried to outsmart the police by hiding in a bean field for hours. All that and more starts right now.
Showcase. Haverhill on Clark versus Woods.
Good morning, Your Honor. I dive before the plaintiff and my clients.
Good morning, Your Honor. Tish Lee on behalf of Ms. Woods, and I believe Ms. Smith has an identical motion up. Are you planning to hear?
My gracing is with your presence.
Oh, because I miss you, Your Honor.
Is that what it is?
Yeah, I just it's been so long, and
Yes.
YouTube is not the same as seeing you in person.
Yeah, I have to go places just to show people I exist outside of YouTube. All right, so I will also call the case of Haverhill on Clark versus.
Thank you, Your Honor, and both Ms. Woods and Ms. Smith are present. Well,
okay.
Yeah.
All right. Go ahead.
So, Your Honor, this is our motion for summary disposition based on the short notice under the CARES Act. I know that the two of us have gone back and forth about this for a long, long time, Your Honor. You know my arguments and my position, but if you want me to spell them out, I can. But for the record, we did file our motion for summary disposition based on the fact that the demand for possession in both of these cases was only 7 days. And we believe the CARES Act requires that those notices, and because the notices were inadequate, that both of these matters should be dismissed for lack of jurisdiction under the Park Forest Doctrine, Park Forest of Blackman versus Smith. And so we filed that motion, and in response, plaintiff has argued that the CARES Act was essentially repealed by a HUD notice of interim final rule. And in our response, we argue essentially three things, three things: that the interim final rule was essentially revoked by HUD 2 weeks later, that it doesn't apply to the plaintiff's property because plaintiff's property is a low-income housing tax credit property governed by IRS Treasury rules and not HUD. And third, that essentially constitutionally you cannot repeal an act of Congress via administrative action by HUD.
Okay. I'm not even going to deal with that last one. This is
All right.
new world, but I get what you're saying. But
All right.
Okay. All right. Response.
Yes. Your Honor, as the court knows, that both of these cases were filed as non-payment of rent cases. Essentially, the argument is a due process notice issue. Notice is the purpose of notice is to inform the defendant or the other party of the claims and allegations against them, so that they can properly defend themselves, or they can be afforded an opportunity to be heard in court. And we're now months in of these two cases. Multiple hearings have been had. Dispositive motions have been filed, responses. Defendants have availed themselves of the court's jurisdiction, to the right to counsel. And the CARES Act, essentially, respectfully, Judge, is a tactic. It's just a tactic. It's a stall tactic. It's used to delay the inevitable. This argument is not based on the merits of these cases. Not one conversation has been had regarding the merits of the cases. What is the defendant? Are the defendants able to pay? Are they seeking resources? Are they challenging the arrears? I don't know this because I haven't had any conversation regarding the merits of the case. Is this effective counsel, or the effective use of this court's resources? I do not believe so, Your Honor, because at the end of the day, it is still, to brush this under the rug, to dismiss it would be contrary to judicial economy and what's in the best interest of both parties. It would be detrimental to the defendant. It would also be prejudicial to my client to delay this any further. We are here. Defendants have just recently asked me for, sister counsel just recently asked me for ledgers. So now we're getting on the merits of the case. So instead of understanding what the status is regarding the arrears, we're now still fighting over this due process issue, this CARES Act issue. And I mean, tenants have subsidies for a reason. They have it. I believe that they need it. And it is essential to preserve these subsidies, like tech properties, Your Honor. And part of effective counsel is to help them preserve these relationships and these subsidies.
Also, when we were here the last time, if you recall, one of the things I said is that you may want to file a new notice.
We did do that, Your Honor.
Okay.
So, I mean, I think both are.
When does that, if it's a 30-day, when is that set to expire?
Actually, I believe it's already expired. And so, instead of, my take on this, Judge, is even if a case was dismissed, it's still.
You're going to refile immediately with a new notice.
Say that again?
If these cases are dismissed, you're going to refile with a new notice.
Right, but my issue here, Your Honor, is it would be detrimental to the defendant. If preservation of these subsidies or these properties or this tenancy is crucial. Multiple filings, even if it results in a dismissal, still works against them. It shows that a case was filed against them in summary proceedings. Yes, it was dismissed, but then another case was filed. Instead of utilizing this time to maybe
but how does,
by way of a CD?
How does that? Okay. I'm not sure how that is detrimental necessarily to.
Well, because they could potentially risk losing their tenancy status. And sometimes, this is lifetime property. If it's lifetime, I believe that if they disqualify, I'm not sure if it's indefinite. But the risk of losing it alone is detrimental to the defendant. So I just don't understand why this is the route that counsel has decided to take on this, when I would like to know, are there challenges to these arrears? Are they planning on paying? Are there resources being sought? Do they have financial assistance? I mean, these are important pieces of information that is crucial in resolving this case. You can't just brush it under the rug. And then what happens outside of court, Judge? They have a fiduciary relationship, landlord-tenant relationship that still exists. And are they going to offer their assistance to the defendants outside of court as well to resolve their arrears?
Well, I don't know, which is not binding on me.
Yes, we understand that, Your Honor.
Because I don't think it confers jurisdiction. I mean, that's not how jurisdiction is conferred in this court. And the approach is, frankly, from my standpoint, jurisdiction has probably been conveyed. The question is have you asserted, in essence, an affirmative defense that would lead the court to determine that plaintiff's case that is fatal to plaintiff's case.
Yes,
That's the way I look at it.
Yeah. we believe so, yeah.
And I get you guys disagree, but it doesn't matter. I'm a judge. So
To ask the court to exercise its discretion and authority, jurisdiction authority, Your Honor, in determining what's in the best interest of national economy and fairness, and what would be detrimental to the defendant and prejudicial to the plaintiff.
well, but here's the thing. There's an interesting thing with affirmative defenses. They've asserted it. I've got a rule on that affirmative defense. That, I think, is where it then goes to, is there a way to salvage this without much else going on? And I don't know if defendants are interested in that at all.
Your Honor, we are interested in that.
So let me ask this part, because my belief is that the jurisdiction of the court has been done. I'm not ruling on the affirmative defense as asserted as of yet. How much is owing on Woods?
Woods currently owes through August $4,188 in rent, $170 in the attorney fees and costs. That's just, we haven't asked for additional costs, Your Honor. And then $4,358 is the redemptive amount. The last
4,300 what?
The last payment that we received on her behalf was on June 9th in 2026.
Okay. And on, hang on, please. And on Smith, how much is plaintiff claim is?
Yes, Judge, I'm showing rent to retaining the amount of $6,915 due knowing through August, 170 attorney fees and costs for a total of $7,085. Last payment received was on 7/1/2026. And I believe there was escrow, but I'm not sure if one has paid with escrow and the other has paid directly to my client.
I have in Miss. How come I do? So in Miss Smith's case, I have no escrow. In Miss Wood's case, I have 1568 escrow. Yes.
I just wanted to mention on behalf of Ms. Smith and Ms. Woods. For Ms. Woods, she paid escrow, I believe, for July and August to the court. And also,
When did she do that? Hang on. Yes, she did. So I have another 1568. Is that what you have?
yes, sir, you have 3136.
Thank you.
And Ms. Woods disputes the balance because they failed to credit her one of her money orders, and she has proof of that. And for Ms. Smith, she paid her July escrow directly to the landlord. She did, which we discussed.
We discussed that the last. I get it. But the balance you gave me is with that credit.
Yes, it is.
So,
Again, no discussions about the merits of the case. If she offered or anyone offered.
look, stop. Everybody just stop. Everybody just stop. All I want to know is this. So, because here's just a practical reality. If I let them assert the affirmative defense considered fatal to the plaintiff's case, what ends up happening is the cases are dismissed. Then they're refiled, which seems to me is going to tack more court costs onto the defendant potentially at some point. So,
Your Honor.
folks, are you real quick, Miss Smith or Miss Woods is what, about 1,000 some odd off from getting everything corrected?
Incorrect, though.
What is incorrect?
Balance that's remaining after you deduct the escrow payments is an amount that is incorrect because they failed to credit her a $500 money order. And then every.
Okay, so let's say, okay, what I'm getting at is this. Let's say the money order is there. Let's say somehow you gotta litigate that. What my point is, Ms. Wood's tenancy can be preserved. It is so close to whatever. But I don't know whether or not you have an interest in that happening.
Your Honor, we do have an interest in that happening. They're our clients. And so what we propose is that this case be dismissed, that no court costs be assessed because it never should have been filed in the first place. And that
But you're not
the
gonna win that because I would be dismissing not on the basis that you view the CARES Act. You might be right if they never invoked the jurisdiction of this court. I do not believe that to be true. So,
and so you'd be dismissing on what grounds, Your Honor?
That you've asserted affirmative defense that's fatal to the plaintiff's case.
All right. And
how? Oh,
so just focusing on Ms. Wood's case for now, Your Honor,
yeah.
it's easily resolvable.
How
And
much?
we can resolve it before
500?
a case is filed, a new case is filed.
Well, maybe.
No, still.
If it's 500, so it's 500, that's at issue? Really? I mean, is that what we have?
Your Honor, plus addition of tons of late fees and so forth resulting from that failure. We've been having a lot of ledger problems at Haverhill. I think they're trying to correct their books. They've been moving around a lot of rents paid through to a security deposit ledger inappropriately. So this has been causing a lot of confusion for Ms. Woods as well as for many other tenants.
Your Honor, I mean, that categorization, we're here for Ms. Wood's case. I don't appreciate her bringing up all the other cases. This is just, I mean, come on, we're talking about two cases here. Let's stick to the two cases. We haven't even had a conference.
Silly.
Honor, I mean.
No, you were even being silly. I'm just trying to figure out how much Miss Woods, I would imagine, wants to have her balance the ledger sat and go on living her life. I don't think she wants to be here, although I'm a pleasant person to be around. She doesn't want to come here and see me. Right, Miss Woods? You all right? All right. Somebody just tell me. Why hasn't the issue regarding the money order been communicated?
Because their only interest was in a dismissal, Judge.
Pardon?
Because their only interest was in a dismissal, Judge. Again, there's nothing based.
We don't need I just don't need the sniping at this point. Where is the money order? Where did you said she had proof of a money order? With her right now?
And she has attempted to address it with landlord and they won't even give her a ledger. This is very common with many tenants that are at.
Well, I don't know about other tenants. I'm just dealing with Miss Woods right now.
She's requested a ledger and they has not received one.
Allegedly.
Okay, allegedly. Give me all right. Here. This is killing me, Smalls.
I mean, Judge, we're pretty reasonable here. If we were presented with if we were presented.
Nobody's
with the order, we would have applied.
I just want this. All right, look.
I mean, our goal is always.
Where's her? Are those her money order stubs? All right.
Would you like me to?
Yeah. Well, Anne, can we get?
I see them yet.
I know. give those to Ann and make copies so that everybody has copies. If you're going to object to them, I will give you an opportunity to object to them. Right? I will. So Ann, who can give me a copy of the ledger?
We have a copy in our possession now. I can provide it.
Okay, and get that too. Make a copy because I can't do anything with that. Please, thank you. Going back to Miss Wood's case, I think, with the receipts. Did you get a copy of those?
Yes, that's, yeah.
Okay. And
Oh, they're souls. Oh, did you get the originals of the receipts? Yeah, I know that.
okay. Has she tried to trace on these at all? Or did
Drug tracing.
I'm sorry, tracing.
Did you want to?
yeah. Did you do a trace on these to try to find out if they've been cash?
I haven't traced them to money order.
Go ahead.
I haven't traced the money, haven't tried to do a
You
trace.
haven't tried to do that?
No, haven't.
Okay.
But I still have all 4 original money orders.
Oh,
I mean, the stubs.
the steps, yeah.
So
the
that-
one that you just
yeah.
have a copy.
Got it. Okay.
But I haven't tried to track.
Money orders, I see why. No, okay, I got it. But you haven't tried to
No.
trace through this company to see.
No.
Got it.
Out of the four money orders receipts, 3 of them are reflected in the ledgers. One of them is not reflected in the ledger, but it does not mean it's not somewhere in there, or it doesn't say who it's made out to, so it doesn't necessarily mean.
I signed everything at the front from the person who stamped them and put her initials on them.
Say that again.
I signed my money orders in front of the attendant at the front counter, and she stamped them with the Hayward Hill stamp, and she initialed the back of them to make sure I had all 4.
Got it.
Also tell us which one is not reflected in the ledger.
Yes, the one that's ending in number 1336.
Yeah, we can assist Ms. Woods and help trying to trace that if that's what you prefer.
So how much was that one?
500.
That's a 500. Gotcha. So I'm only, bear with me because sometimes I've got to catch up, okay? So there are 4 things here, right? But only one of them is at,
Missing.
for you,
Mhm.
right?
Yeah.
And that's the one ending in 36. So it's not looking at all 4, it's just got it. Mip, are all of these $500?
3 are 500. One is for the 58. So 1,500. 3 of them are 5. One of them is for the 58 because they can only do 500 at a time.
Right.
Yeah.
Okay. So
If I was allowed to pay online like everybody else could pay online with an e-check, I had to go and get my account unlocked because I could even pay from my banking account online because she had to unlock my account in order for me to even pay it online instead of me just going to get the money orders from the store and walking around with $1,500.
okay. So the portal's locked.
She unlocked it last month or when I went to her and said, why can't I pay online?
Okay, so
Now my portal is unlocked, but everything's going into escrow now.
right. And then that means you have to go to your bank and get cash so that you can pay it to. I got you. Okay. So I see a series of $500 credits. And so let's see. Golly, well. Yeah. These four that you gave me, you took those all in at once.
Yes, sir.
Because
I
that's
have
how
the
you
same date on them.
that's how you pay your rent.
Yes, and then the sequence numbers all kind of match except for just one of them, but all the last numbers match in sequence. Except one. I think one is like off by one number.
They're all different.
Well, I see.
That's the last digits of them. They follow in like numerical order.
5, 6, 7, 8, but the next number may not be
Yes.
sequential. So you can't look at the last three. It's not that way.
Yes. So the very last.
The last digit.
Yes, sir.
Gotcha. Okay. So is there a way? I mean, I'll just tell you what my gut's telling me. My gut's telling me that it's not that she didn't pay. Somebody's missing the receipt of it. I mean, that's what my gut's telling me because she goes and gets 4 money orders every time to pay her rent. And I find it a little bit difficult to believe that she then took one of those and didn't give it to the landlord. Quite frankly, I had the port open, but we wouldn't even have it.
Portal is closed, obviously, Judge, because it's in litigation, so that is why it's the
It was closed before the.
Hold on. What sense does that make?
it's not uncommon for the landlord for them to lock the portals once it's in court until it's resolved.
Why in the blue blazes would you do that?
I am, Judge, that's
Blue blazes is a legal term.
But if I may speak, at the time, a lot of the residents, there was a transition of systems, so that's why I opened up the portal. It wasn't that we went in and maliciously locked the portal. There's a transfer of a new system we're going to, and a lot of people they got locked out. So we had to reopen the portal for people, but it wasn't anything that we deliberately did. But it does get locked out if you have an NSF or insufficient funds or in the middle of legal. That's when the accounting department, the corporate will lock it out. For hers, I don't show was locked out.
I was locked out because you opened it. I sat in your office and you opened it while you were sitting there.
But that's what I'm saying. It wasn't locked.
But it wasn't locked. I just wanted to make sure, ma'am, I was just trying to figure out why were you locked out? And it sounds to me like it's a systems issue as opposed to a policy issue, just locking you out. That's what I'm.
I forget the manager's name. She said that corporate locks the accounts in litigation. Portals in litigation.
No, that's what I
she,
said.
she did say that. That's corporate. That's has nothing to do with my.
Why would they do that?
I don't know, Judge.
That makes I almost said a bad word. That makes no sense. Especially, I could see it if it were a termination case, maybe I could see that. But on a non-payment of rent case, why are we making it hard for people to pay? I don't get it.
I can defer to my client. She knows.
The system does not allow a partial payment, Your Honor.
Well, which is also stupid, but I get that. That happens with
Which is why I took the initiative to open it up to allow the partial to make it easier for the resident.
Why aren't they just allowing the partial payments? People don't get a big check all at once. All that money doesn't go into their account all at once. So even if you tack on a late fee, but she can pay through the portal when she has it, right? It just doesn't make any sense. But it's unlocked for you now, right? You can make partial payments.
I put $3,200 in escrow, which is July's,
Right.
August rent. So that's it.
But you don't. So okay.
So
And that's fair. You don't know whether it works because you've been paying to the court.
Because I've been paying to the court. Yes, sir.
Got it.
I knew it, but I did go in and piggyback to make sure it was able to take my card, even though it was a $48 convenience fee to pay with my bank card. I can still go in and see that I was allowed to put my card in.
So they charge you $48?
Your Honor, I've instructed every resident to link your e-checking, which is only $3.90.
Got it, right.
It's gonna cost you an offensive amount.
Yeah, I got you. Do you understand that, ma'am? That's not uncommon.
I wasn't unable to pay with the e-check even before we had our court. That's when I got it unlocked. But by the time I got it unlocked, I already had paid rent with the money orders.
All right. All right. This one's gonna. So if I take all the money that's in escrow, she's gonna owe
$1,222, but that does not
$1,222.
it does not include the $500 if that is located. Obviously, it would have.
I think she paid it. I'm gonna be honest with you. I think something. My gut is telling me something happened on your end, and I don't say that many times at all in cases involving money orders. But she gets 4 money orders and goes down and pays it.
I understand that, Judge. However, again, this is news to us, so this could have been easily reconciled outside of courts. We would have an answer for you now, but we don't, because now we have to go back and trace it. Both sides can trace this money order. And if she needs to be credited that $500, my client will credit her that $500, which would leave her with a $722 bill.
I tried to reconcile the first amount and no one would talk to me about the first amount that you said that I owed. And that's why we're here right now. And things are accruing the way they are accruing because no one would sit down and explain to me where the first amount of money came from when I asked them to. I kept getting dismissed.
Your Honor.
Miss Woods, I hear you. Okay. And Ms. Woods, I'm not dismissing you. All right. That will never happen here. You understand me? So I get that. And you're right. People, you're trying to just do your business and people need to respect that and they need to talk to you. I hear you. How was, and I guess I'll ask counsel, how was, if she were to get the credit for the 500, how the 722?
Well, Your Honor, we think that they should also waive the late fees and the other charges, the $48 charge, because it was impossible for her to pay otherwise.
Well, it's not in the $48 convenience fees, a weird thing. I don't know what I quite do with that because it's not something where that's not an uncommon thing in the system, which is why she's saying link your e-check. And I don't know, I'm not even sure why there shouldn't be a fee on the e-check. Because they're going right.
It's being wired directly to their.
Yeah. Whereas I get it's crazy that it's $48, but I get it. I get that.
In Your Honor, that wouldn't have brought her to a zero balance. So
What would have brought her to a zero?
They were asking to waive late fees, so on and so forth. The late fees automatically accrue unless there's a zero balance on the account. There was no zero balance on the account. Even if we were to credit that $500, it wouldn't have been a zero balance. She still would have had a balance. And so those late fees are appropriate.
Well,
Your Honor, I have never been told that there was a missing money order. I do not dispute that that could be the case, but this is the first I'm hearing of that.
I know.
It could be they didn't put the right unit number. It's easily.
Did look the right one?
It could have been the wrong unit on this money order. I was never told that.
Gotcha. I got you. No,
This is the first I've heard of this.
no, I thank you. And I appreciate that. I get,
Residents. But I wasn't told this till today.
yeah. And no, I get it. I'm not saying that you wouldn't have done something. It sounds to me like when they come talk to you, they're hurt. I don't think what she was saying was really necessarily directed at you. Something tells me, because you're the one that got the portal unlocked. How much do you have? How much are late fees for you guys? That count?
50, 50.
So what would be the total amount of late fees that you're looking at?
I see 4, 5 months at $250.
200 or 250?
255 months.
Got it.
I'm sorry, Judge. I'm gonna have to object to any waiver, any late fees, because of the fact that, again, the last time she was adding zero balance was in March of 2020.
Okay, I get you object.
My client is within the right to collect pursuant to anything that's within the lease, Your Honor. And so
You want me to go through an analysis regarding your late fee, because your late fees have to be accrued to your client efforts in attempting to try to collect rent.
right.
If I were to find, and I'm going to tell you, you can talk to the people at McKinley because I went through it. If you want me to order that, I will. It will be a nightmare for you to get the information to me that you want. I just give you that warning, counsel.
I guess so respectfully, Your Honor, the court is getting frustrated because,
I'm not frustrated.
again, Your Honor.
Trust me, if I were frustrated, everybody would know and run. I am not frustrated.
So I believe that this case could have been resolved outside of the courts, without the court's intervention.
Well, I'm here now.
And we can still do that, Your Honor,
Okay.
if they're amenable to a resolution.
Everybody needs to just stop talking. Because all I'm trying to do for right now with Ms. Woods is this. And I'm making my thoughts rather clear. I think she paid the 500. I think the 500 is just not, it's missing somewhere. It may have got, I don't think anybody tried to do anything intentional. I'm not saying that. But the way she would pay her rent, in my experience, somebody doesn't show up with 4 money orders and they keep one. Right? That doesn't happen. And then keep the one that sequentially would be in the middle of the other 2. That none of that makes any sense to me. Yes.
Correct.
Yeah. I just, so it's, no, I get it. I get it.
Going to find around the same time, which would have been a $500 difference in her balance, which at that time, if it were received and applied correctly, it would have been, she would have still had a remaining balance of $462 if that $500 was applied.
Okay. Here's the deal.
all I'm trying to do, Miss Woods just wants to get to zero. Right, Miss Woods?
Yes, Your Honor.
And then that way she can figure out how to go on. Now that the portal's open, she can figure out all of that. She can get her rent paid. We don't run into the money issue. So all I was trying to get to was that she's at 720. If the 500 comes off, she's at 722. Then there was a indication regarding late fees, right? So if I just momentarily say she's at 722, and let's say I just take 200 of the late fees. Say right now, I'm not going to worry about them. Then I'd have to ask you, could you come up with $522? Or let me say, when could you? Better way.
2 weeks will suffice.
Pardon?
2 weeks will suffice. 14 days. If I can get 14 days, I can come up.
Pardon?
14 days.
Could you explain to me again how you come up with 522?
Because what I did, she's at 12. They gave me a number 1222. If I say I take the 500 off, right? Because I think she paid it. We just have to figure that out. Then I'm at 722.
Is that court costs and court fees?
Hold on, just a second. So then I'm at 722. Then I said, okay, there's $250 in disputed late fees. At some point we'll have to figure that out. But if I take 200 of that, and I just take 200 of that, I came to 522. And then I asked Ms. Woods, how long would it take you to do that? And she told me 14 days. It's funny. It's funny with all of these lawyers in here. The only one that was following me was Miss Woods. Go ahead. What?
I just wanted to note, counsel just stated that if the $500 had been credited, her balance would have been 462. That would have been early June.
Early June. Okay.
462 in early June. And then I see in July, they charged her the 568 plus a $50 late fee. That 568 went into escrow. In August, they charged her 568. And this ledger says $40 in August late fees. That was put into escrow.
1568.
So
Plus 40 in August. And so just from this ledger, it seemed to me that her balance is more like 462.
for what?
462.
We're right. And actually, had I taken the whole 250 that you disputed, I think we're at the same number.
I think it would have been even less because that.
No, so when you said you disputed 250, I just rounded to 200 to see where she was in terms of funds.
Mhm.
I didn't take the 250 off. If I take the 250 off, I'm at 722 minus 50. No, 722 minus 250. Hang on a second before you say anything. 672. No, you can't get 472. What'd you say?
472.
47.
Which is we're $10 difference.
Yeah.
That's what I'm saying. Had I taken the whole 250 that you're disputing, we'd be talking the same number. Basically.
Yeah, I don't know where council's 1222 number comes from, but we are
balance. That's the balance that she owes less escrow. That's where we started from. That's where the 1222 comes in. And then the 500 is, then you take off 500 of the money order. And then you got $250 of disputed late fees. Part of those late fees I may be able to solve right now. Did you charge her late fees for July and August?
Yes.
Yes. And
That's the $50. Those come off. She paid her money into escrow. There's no late fee.
I'm wondering, I mean, we might be looking at different ledgers because the final balance on this one that we just got from council is 4188. And when I subtract, I believe it's
Right.
136 in escrow, I get 1052.
That's before the attorney fee. Of
And we don't believe there should be attorney's fees.
This,
course.
no, I know. I hear you. I get all of that. And folks, somebody's going to have to move on the numbers. If it's going to get resolved. Miss Wood's case is so close.
John, we agree, but we just want to say that you can rule today that you're denying our motion.
Or I can not rule at all.
But if
Today.
if you render a judgment, then you've denied our motion.
If I do what?
If you render a judgment, then you've denied our motion.
No, that's not true. That's what you would like to think, but that's not true.
We've moved for summary disposition. We don't have a ruling.
You're right.
And so you can't proceed to judgment unless you've denied that motion.
Have I said I'm issuing a judgment?
Are you?
Oh, when I'm issuing a judgment, you'll know.
Okay.
I'm just trying to figure out how to get her to zero.
And we know that we're close, Your Honor.
And here's what I'm saying. By default, the case gets dismissed, frankly, with another payment, without a judgment. Because she would have zeroed. That's what I'm saying. And then Miss Woods can just go on and not have to talk to me, you know.
And absolutely, if that's what she prefers to do, she's our client. We will accede to her wishes.
I mean, but you understand what I'm saying, right? So,
I understand what you're saying. My only thing was when I originally was told that I was owed the 352, and I asked her where did it come from. No one explained to me where it came from. But when I pulled out my security deposit payment program, 352 was the last part paid for my security deposit. The exact amount was what they told me I owed. They transferred from my rental account all my money over to my security deposit, which made me pay over $250 for a security deposit that was only supposed to be $2,350. That's why you wanted to see the case again, because when I told you that I didn't believe that I owed that money, it was like, okay, well, we need to see the case again so I can check.
I remember.
Yeah.
I can speak on that, Your Honor. And I took over Haverhill in April.
Lucky.
Yes.
Yeah, go ahead.
My observation was when they moved in, a lot of the residents weren't understanding. When they paid their monies, it sat on the resident side. It was their deposit with their intentions of having it be that. So when they would look at their ledger, they would think they had a credit. Once the accountant moved it over to deposit, that's when you would start to see then the negative pop up on that. So that's the first thing I saw. The other thing that I can honestly say, because I've experienced it, when I'm being cursed out, staff is instructed not to speak to anyone. I've been cursed out despite my motives to try to resolve with Ms. Woods. I've been cursed out. At that point, we disengaged, Your Honor. We're just not going to stand there and be there.
I have never cursed you out. Yes, I have became angry, but please do not stand here and say that I have cursed you out, because you would have called the police on me and had me escorted out of there if I was to cuss you out. You would have not just allowed me just to cuss you out freely and just walk away.
I should just cuss everybody out here. Thank you. I'm sorry.
Despite the effort that I tried to resolve, sometimes we don't engage because of.
No, I get it. I understand all of that. I think folks, you just have to realize from my standpoint, week after week after week, I see folks that are so far behind, it's hopeless. And ultimately, they're at some point. I'm looking at Miss Wood's case and I'm just, maybe I get happy because it's just not that far off and she can be at 0 and everything can be okay for her. That's what I'm saying. And I don't, the months outside of the last 2 months, the months for the late fees are what months, Miss Weekly?
June, July, August,
April, May, June,
August.
April, May, June. And that's when you paid with money orders, ma'am? I'll tell you what. Somebody needs to find that 500. Here's what I'm going to suggest to the parties just as a framework to try to resolve this. I'm going to adjourn any ruling on this matter to just give me a Friday.
Oh, you want Friday?
Well, when's my next Tuesday?
August 25th.
Oh, all right. I'm adjourning any ruling on this case to August 25th. Okay. That's a Tuesday. I am inclined to, and I'm doing this just as a framework for the parties, I am inclined not to waive all late fees because she was bringing everything down there. And that in and of itself is a hassle, right? I'm inclined to believe, although you have to find it, that the $500 was paid. I'm inclined to split any costs that would be associated. Right down the middle, 50%, one way or another way. I think at that point, if you come up with a number from that, I think from what Ms. Woods told me, 14 days from now, she could have that paid and be done. So your case, ma'am, I'm going to adjourn out to the 25th. Let your attorneys work with the other side. They kind of got my framework of whatever. And that's it. We can just be done.
Okay.
Fair enough.
Thank you.
Thank you.
Thank you. Okay, I have a question on Ms. Smith's case. When we were here July 30th, and I'm now in August, I don't know. I got my stamp on that was, you say it was June? Okay. It, because what? No. Thank you. No, you're right. Okay. Well then. Yes, right. Okay. This should have been June 30th. The stamp in the file was July 30th. Okay. So June 30th. And she made, so has she paid rent twice to the landlord or just once? Just once? Okay.
I'm sorry, Judge, which case are we talking about, Smith?
Well, I'm talking about Smith. Okay, so let me ask this. Did you get a ledger on Smith?
Yes, Your Honor.
Okay, so I'm a little bit worried because her balance is up there. And I'm trying to figure out,
Your Honor,
yeah,
we're actually working on multiple fronts for multiple sources of assistance from Ms. Smith. She has suffered tremendous hardship over the last several months.
got it. Okay. Those, I don't want to say this because this is a weird word now with funding and stuff. Are those prospects?
She's been provisionally approved for 4,000 and pending payment on the balance.
Okay.
Yeah, she's
So
also hoping
go ahead.
to be, she had employment lined up, which got sidetracked, and her employer is trying to find another position for her. So we're hopeful that she's also going to be employed sometime in the near future.
Okay. So the provisional approval of the 4, when you say that, she's got to get the other part done, which according to their is about another $3,000. Okay, let me ask this. I get the employment part, but how is that looking in terms of other sources right now?
Hopeful.
Okay.
And if you like for, Trish, I can give you more detail.
Yeah, in a minute, but let me just answer this. I'm just trying to get a framework. That 3,000 can somehow be closed, you think? You're working. Ms. Smith, you okay? All right. Hey, pardon? It's okay. Don't apologize. You're good. Okay. All right. Now, your case is a little bit more. You said you were on, that you had the provisional 4,000. Is that through Hawk or is that through?
The Emergency Housing Fund.
Got it. What are the prospects of this, of the gap with the 3,000 being closed?
Waiting for responses on 2 sources and hopeful, but if for any reason the funding is not available, we believe they would assist her in relocating.
Okay.
With time. I mean, she has to put in applications, etc. So
Ms. Smith? You gave up hope there for a minute, didn't you? When you heard that, right? So let me ask you this. Why are you giving up hope?
It's like it's giving out. I'm scared. They just been trying to transfer departments at my hospital because I had a cardiac episode and they fired me from that department. And so I'm trying to work with HR to get into another fund. I'm not well. And I have a disabled daughter that I'm trying to protect. And this is the safest place I've ever been. I don't want to lose this home.
All right.
I care about this place so much. And I'm trying everything I can. I don't have parents or anything. I'm alone. And I want to pay them. I want to pay my bills and I want them off.
I know you do.
I feel like I'm dying. And I am in therapy, but it only does so much. It does not pay my bills.
Okay. All right, Miss Smith, a couple things. You got a lot going on. Sometimes one always has to look at, you kind of have to put things in order, right? Because we all have our lives and we can't deal with everything that's coming at us.
Very overwhelmed.
Huh? I know. And I can tell. And thank you for sharing all of that with me because I didn't know. Okay.
Okay.
Let's try to do this. Let's try to take one step at a time. Because we're trying to grab everything, right?
Yeah.
And that's where it all kind of gets overwhelming. Right?
So that's a bulk line, yeah. It's
What do you say?
fix everything at once. I'm learning to not do that.
I'm the same way, and I have to kind of back up, right? So what I'm hearing in this case is there's 4,000 that may be out there. We're trying to figure out the 3,000. It gets scary, and I asked the question, and counsel was answering me. It gets scary when all of a sudden, if that falls through, then we got to do X. But we don't know whether we have to do X, right? So at this point, we're not going to worry about it. Okay? And what I'm inclined to do, would the time work to try to figure, will you be the 25th? Yeah, would you be able to have an answer on that other piece, you think, by then, or? Hmm?
Well, this has been human for a long time.
Then I'm going to adjourn this one out to the 25th also.
Are we looking at morning or afternoon?
That is morning. Okay. And Miss Smith? You got a lot on your mind. All right, listen. Okay. Regarding this issue, and this is the great thing about me and me. Okay. Yeah. What'd you say? Well, thank you. But I want to tell you this, and it's true. I want you to worry about you got good lawyers here. I want you to worry about the other stuff you've got going on. Work, your job, your health, your daughter. I want you to worry about that. Okay? With regard to the case, they got you on that. And the other thing is, plain and simple, nothing happens until I say it does. So you're not going anywhere right now. Okay? So I don't want you worrying about that. Okay? All right. And I'll adjourn it out to that date. We'll see on the 25th. We'll get a better handle on the funding part of it. And
I won't give up. Thank you.
what?
Thank you.
Don't you dare give up. Because then I got to go out Got to get Alan. We got to go out. We got to find you and everything. And we got to like have that whole conversation. We don't want to do that. Okay. You're welcome. All right. We'll see you guys in a couple of weeks.
Thank you, God. Sorry, but, the money orders that were provided, can we see the back of one of them, just so she can go back to the office straight?
Did she leave?
No, she had to go.
Oh, okay. She had to go to work. All right. Yeah. Take care of yourself, okay? Court does call the cases. The people, or not the people, excuse me, Anderson versus Lyman.
Good morning, Judge. Is it still morning? No, it's
Nope.
already.
We went over. All right. Good one. This is, I think, plaintiff's emergency motion, correct?
I believe we might have docketed something. It doesn't appear as though the
With final settlement and so I should let you know that I received a email this morning from Miss Lyman. And she's at U of M hospital, not being able to make the court today. And she has her tag on. So that's the first thing. The other issue was, I believe, Miss Anderson had sent to the court based upon, I guess, the inspection or whatever, that what looked like red tags on the door to the premises.
Yeah, my understanding is she's been very prolific in sending proof to the court. And I've cautioned her to have that entered as evidence when it comes to trial. That would be my preference. But as far as the Miss Lyman's non-appearance without formal pleadings being filed or contacting me with news that she's in the hospital, I find that kind of suspect. I would ask that default.
Well, let me just say this. Attached is her admissions tag, but I don't have the date of it. It's around her wrist, but I don't have the date of admission.
Your Honor, my client has heard nothing. I have heard nothing. My client has begged and pleaded for admission to the house so she can assess the damage. She's been refused at every turn. It's high time that we get on with our lives here. I would argue that she hasn't exhibited cause for being absent at today's date with no formal papers filed with court, no contact to plaintiff's counsel or the plaintiff.
It seems to me that I'll give some deference to the fact that she sent the tag in, but the other, I think, problem in this case is that we contacted, based upon the tag command, we contacted Pittsfield. They have indicated that the house is unfit for human occupancy.
If I may interject, that wasn't the problem or the case when Miss Lyman took possession. I've been told that there are holes in the wall, many holes in the wall, more than you can count. Who knows what's going on with the plumbing or the electricity? And both of those are going to cause Pittsfield Township to take notice. I've seen tenants destroy property, and it appears as though this tenant is trying to destroy the property for whatever reason.
Yeah, I'm not prepared necessarily to make that because there was a list given, but not to us. Of from Pittsfield. There is what was it? I believe my staff told me a September 14th check-in to determine what repairs had been done with Pittsfield. And I think they were going to check in with Miss Anderson. That they said September 14th. Again, that may be just for them a calendaring thing to try to determine what repairs have been done and do you want another inspection, which is typically how they would work. So I don't know that the September 14th date means much in any event. So here's what I'm going to do, because we specifically asked, because it was red tagged, whether it was condemned. It was we were informed that they don't use that terminology. So I don't know. I'm not sure what to make of what they're saying.
So whatever the verbiage is, maybe it's not condemned, maybe it means the same thing.
Well, right. I kind of thought, sometimes in this world we want to say something, but everybody thinks that that's a bad word, so we make up a new phrase for whatever. And I get that. So what I think I'm going to do is this. I'm going to kind of split the baby here, where I'm not going to give a judgment or do anything today because she's not here. I think at least has sent the thing in saying she can't be here.
Oh, Your Honor, excuse me again.
Go ahead.
I was told that she hasn't paid escrow for August, and we're into August now.
Right. She has not. But the only thing that would entitle you to is an immediate trial for possession. I think it's going to be, I think it's going to be the long and short of it happening in different ways. What time is the miscellaneous block on Friday? Three.
Yes.
All right. So I'm going to adjourn these out to this Friday at 3.
Very good.
Person. And at that point, be prepared to do something. I should have, if she can't be here or whatever, I'm just going to make my ruling on what's there.
Very good.
Okay.
Thank you very much, Your Honor.
Thank you.
Thank you.
Good morning. Are you Lisa Kloosterman?
Yes, Your Honor.
We've met, at least by Zoom. I'm Judge Middleton. You're here on a charge of Three Rivers Ordinance, disorderly person. That is a misdemeanor. Thank you. Thank you very much for your help. It is punishable by up to 90 days in jail and a fine of up to $500. Let's take a look here for a minute. You're in jail, and you've been in jail. I looked at this yesterday. Now, disorderly person, we had someone just a few minutes ago that pled to that charge. Basically, it's causing a disturbance in a public place in the city of Three Rivers. It's alleged that this happened on April 23rd, 2026. According to Mr. Reed, he met with you and you've agreed to plead to this charge, he's gonna recommend a minimum fine and time served. So if, and I will follow his recommendation, meaning if you plead guilty to this, I'm gonna fine you $125. I'm gonna give you 13 days in jail, credit 13 days. Do you have anything else holding you in custody?
No, Your Honor.
All right, let me explain a couple other things. Do you understand that if you do plead guilty to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Jackson is here with you from the Public Defender's Office in advisory capacity. But if you wish to have an attorney, I could appoint one for you. We could have a trial. But if you plead guilty to this, there won't be a trial. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, Your Honor.
And again, I don't remember, did anyone threaten you to get you to plead to this
No, Your Honor.
or promise you anything?
No, Your Honor.
We had several of these earlier this spring and summer, mostly on Main Street. Reggie King was in some of these. Elizabeth Conway, you guys were living on the street downtown. Let me see what it is you supposedly did. Yeah, there's a video of you, I'll just read, peeing in the flower garden in the middle of the alley. And then you pulled up your pants, got on your bike and left. So that's the allegation. You accept that?
Yes, Your Honor.
That probably isn't merit 13 days in jail. I think you failed to appear a time or two. And I don't know what they set the bond at. $200. You failed to appear in May. And so I issued a bench warrant, set the bond at $200. Where are you going to go if I let you out of jail?
I have a home now, Your Honor,
Where's that?
on 7th Street,
What's the address?
715 7th Street.
All right, we've had a number of problems at that house. Who lives there with you?
Jamie Hay.
All right. Where are you from originally?
Originally, I'm from Mendon.
Well, you don't need to be in jail any longer for this. 13 days jail credit, 13 days. 0 fine. But I have to order $125 costs. I'm going to give it until September 30th to pay that. That's about 2 months. If you need more time, you come see me. I could just leave you in jail for 2 more days, but I'd just soon lay you out and see if you can pay the minimum court costs. Have you got a way to get back to Three Rivers? Will somebody come get you?
I'm not sure yet.
Do you need a bus pass?
Repeat that again.
Do you need a bus pass? I could give you a bus pass to get from the jail back to Three Rivers.
I have a tablet. I just need to connect it to Wi-Fi.
All right, well, if you need a bus pass, you can't get a ride, walk from the jail up to here and the bailiffs can give you one to get you there. All right, Ms. Kloosterman, you're gonna go to jail. Obviously, this kind of thing goes to the quality of life for everybody in Three Rivers. Hopefully you can get a better situation than this. They were really upset about this earlier in the spring about people doing this kind of thing downtown. So you're good to go.
Thank you, Your Honor.
Said Hanson?
Yes. Good morning, Mr. Hanson. This is Judge Middleton. I'm here at the courthouse. Your lawyer, Mr. Luke Knopfinger, is up here at the courthouse with me. I'm gonna set up a private breakout room where you can talk privately with your lawyer. Then we'll see what we need to do from there, okay?
Yes, sir.
All right, very good. It should sign you automatically, I think, but. All right, we return to Mr. Knopfinger and Mr. Hanson. Mr. Hanson, you do have someone that's here in the courtroom who's interested in your case. They've been waiting patiently all morning. I thought I'd just let you know that. Mr. Knopfinger, what's the status here?
Mr. Hanson to enter 2 counts of domestic violence in the 2nd degree. Prepared to enter that.
So clarify, 2 counts of domestic violence, 2nd offense. We would dismiss the remainder. And one of the individual here is one of the victims.
All right.
She's aware.
Okay, Luke, why don't you come back in the courtroom? We're having some sound issues. We'll leave Mr. Hanson where he is.
Let's jump back there.
No, Ross, let's go ahead and deal with your matter. What are we doing with Mr. Tepfer?
Mr. Tepper is going to be left on for prelim. We're going to ask, we'd be willing to waive the 7-day and ask that it be set an additional week or 2 weeks out, whichever your honor would prefer. I came into the case late last week and we're having some fairly fruitful negotiations with the prosecution, but there's a lot of body cam and things that need to be reviewed. And my only availability is Monday afternoon. And by the time Mr. Tepper and I are done, we're going to be having witnesses come in and things like that Tuesday.
Deborah, have any objection to that?
No, we have no objection to adjourning it to whatever is acceptable to the court.
I'm going to continue this to August 25th, 2026 at 8:30. And if we need a prelim, it will be 9/1/26 at 1 o'clock. Mr. Tepfer always makes his court appearances. I'm not concerned about him not appearing. Mr. Tepfer, you stay in contact with your lawyer. You're going to get together and watch discovery videos that may shed more light on this, whether the matter can be resolved or whether it needs a prelim. Tricia Tepfer's case, I think, is set for this afternoon. I'm not sure what's up with her.
Is that before your honor?
No, it's before the Honorable Robert K. Patterson.
Mr. Tepper is subpoenaed for that hearing. And
let me make sure I got my facts straight. Yes, it is set for 6.
Check with Angela.
Luke Knopfinger is the attorney in that case. Maybe he can give you some insight on what we need to do there.
Very good. Thank you.
All right, Mr. Tepfer, don't go away yet, but your matter here has been adjourned 2 weeks.
Thank you, Your Honor.
Thank you. Talk to you.
Yeah, they may know here shortly whether he needs to be here at 1 o'clock or whether he is excused. All right, Mr. Hanson, we're going to focus on your circumstance. Once again, I'm here. The complaint alleges that on or about, nobody ever says that, but lawyers and judges, on or about July 26th of 2026, it's alleged that you have made an assault upon Ernest Coons with a large brick, but without intending to commit the crime of great bodily harm or murder. It's commonly known as assault with a dangerous weapon or felonious assault. That is punishable by up to and a fine of up to $5,000. You're also charged as a habitual offender, second offense, which would make the felonious assault punishable by up to 6 years in prison, and the domestic assault third by up to 7.5 years in prison. My understanding of the plea offer is they're going to dismiss all of the felony charges for a plea to 2 counts of domestic violence second, one on each victim.
Yes, Your Honor.
Mr. Hanson, the prosecutors agreed to reduce the felonies if you plead to 2 counts of domestic violence, one on Twyla Coons and one on Kurt Coons. Domestic violence, second offense. Excuse me, Laura, could I have some water? Excuse me, is a misdemeanor, not a felony. It's punishable by up to a year in jail and a fine of up to $2,000, but they are not felonies. Ms. Davis, you confirm the plea offer?
That's accurate, Your Honor.
And you confirm that, Mr. Knopfsinger?
Yes, Your Honor.
Are you going to plead to 2 counts, misdemeanor counts of domestic violence, second offense, Mr. Hanson? Is that correct?
Yes, sir.
Did anyone threaten you to get you to plead to that charge?
No,
Promise you anything to get you to plead to that charge?
no.
Laura, I don't know if you can hear me. Could you bring me some water, please? I'm not sure that she's hearing me today. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or a jury? There will be no trial. Do you understand that?
Just ready to get it over with.
All right. If you had a trial, you'd have the right to be represented by an attorney. Mr. Knopfsinger is here to represent you. You could also hire an attorney for your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify in your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent. Unless I'm not sure if you can hear me.
Yeah, I've got you in my pocket.
Oh. Well, all right. Finally, you have the right to be presumed not guilty or presumed innocent unless they were able to prove guilt beyond a reasonable doubt. You understand all that?
Yes, sir.
Well, let's see what we can discern here. This happened at Millard Court in Three Rivers on July 26th. Is that correct?
Yes, sir.
Who is Twyla Coons to you?
The mother of my children.
All right, that qualifies for a domestic violence. Who is Kurt Coons?
The father of Twyla Marie Coons.
So he would be your former father-in-law, is that correct?
Yes, sir.
All right. Did you show up on that Millard Court address that day?
Yeah, I was in front of the driveway.
All right, and were you upset?
Yeah.
And upset about visitation with your children?
I was I was upset that my finger got bit and I was bleeding.
Well, did you pick up a brick and
Before that, I was upset, yes. Due to visitations or whatever. And then the brick was picked up after the fact of my finger.
All right, so your finger got injured, you picked up a brick. Did you threaten them? Said you were gonna smash their heads in?
No, I slammed it on the ground. I originally said, where do you want the brick? And then I just slammed it on the ground.
You said what about the brick?
Where do you want the brick? Or where do you want it? And I slammed the brick on the ground.
All right, meaning where do you want it? Like, not on the head. All right, you've been drinking. You were a .149 on the PBT. Were you intoxicated?
Yeah, yes, sir.
All right. Yeah, your finger. You also had a bunch of other injuries. Not sure what that was from.
Tackled to the ground. I was tackled to the ground and my finger was bit.
Who bit your finger?
Kurt Combs.
Ms. Davis, are you satisfied with this factual basis?
Just to clarify, I didn't catch, but I believe that he lived with
next door
victims at one point.
All right.
Yes.
So,
yes.
Okay. So yes, with that, we are satisfied.
All right. Mr. Knopfinger, are you satisfied?
I believe that.
All right. As a rule, Mr. Hanson, the law requires that I schedule a sentence in a domestic violence case at least 10 days out to give opportunity for the complainants to be heard. Are you Twyla?
Yeah.
Ms. Davis, what's your preference here?
Your Honor, we've had contact, obviously, from Twyla by phone. We have not had any contact or response to the information that was sent out to her father. So if the court would like to go forward today, Twyla is here, and I think we could move forward with a sentencing if the court so chooses.
All right, Ms. Coons, would you come up and have a seat over here? At this point, Mr. Hanson has been in custody for 17 days. He has an unpaid seatbelt ticket from 2006. Excuse me, it's very annoying to hear. And we're gonna get that paid. In the old days, excuse me, they would have suspended your license for that. Maybe they did.
Yeah, I don't have a license, Your Honor.
All right. Mr. Knopfinger, what would you like me to know here?
Yeah, a couple of things, Judge, and you laid it out there. There was a skirmish before this that Wayne referred to. There have been, as I understand it, problems in the past. They live right next to each other, and I guess there's a long history here. I think it came to a head that day. The meeting with Wayne, he has been in custody for 17 days, and I think he's remorseful here. I watched some videos too. I think he was really seeing red that day too. So I would ask the court with all that to consider in fashioning a sentence that I think would be good for him. I've not spoken to Wayne about the possibility of a probation, so I don't know his position. But the amount of time that he's spent in jail, I do get a sense of remorse from Wayne as well. Thank you.
Ms. Davis, what's your position here?
One moment, Your Honor.
Todd, could you give me a couple Kleenexes, please?
Your Honor, the victim in this case is obviously emotional about this. They do have children together. She does reside with her family in their home that is next door to a friend who was allowing Mr. Hansen to stay there for the purpose of being able to have parenting time with his children. Probably not the best situation being right next door with the history that Twyla has discussed, where there's been several years of domestic violence abuse from Mr. Hansen toward her. You know, they are, for lack of a better term, stuck together because they have these children. However, we believe that there needs to be some oversight here. His intoxicating substance use certainly contributes to the animosity and issues that are going on here. So we would request that he be placed on a probation and that any jail time, further jail time, be at the discretion of the court, making sure that there is no assault or threatening behavior, no use of illegal substances or any intoxicating substances without a doctor's prescription, so that we can hopefully ensure that he gets on the right path and is an appropriate individual in front of his children and their mother. Thank you.
Ms. Coons, anything you want to say? Thank you for being here and your patience. Mr. Hansen, you show up drunk at your ex's house in the middle of the day, and you're mad about visitation. You have the privilege of living next door. Apparently you never were married, but you're the father of these children. That ain't a good situation. Go ahead.
I definitely need to leave this alcohol. Like I was upset. I was angry about our separation. I was angry about visitation, and I chose to get intoxicated. That was on my behalf. I do apologize. I know that doesn't hold much, but I agree. I agree that that's one of the biggest things I've been focusing on while I was in here is that I probably need to leave substances alone, and it honestly, it wouldn't hurt for me to talk about getting some medication, like getting put on some anxiety medication or something.
All right, I guess I get that same impression. Are you employed?
I was, currently not anymore.
Where did you last work?
Roosters.
How recently?
Probably 6 months. I went through a phase where I didn't care. I just wanted to be in my kid's life. I was juggling, trying to avoid homelessness, be a dad week on and week off, and seeking employment. So it was a lot, and I turned to alcohol to try to, I guess, feel okay about it, and that just made a monster out of me, bro.
All right, where are you gonna go if I let you out of jail?
I would assume next door, but if not, the center would be my
Well,
other
I'll
option.
allow you to go there, but I'm gonna put some restrictions on this. One option, I could just give you a year in jail, which would be about 300 days. I'll be retired before you get out of jail. Then you'll be somebody else's problem. But I'm gonna try to keep a lid on this. I've dealt with you guys before. It's not a great situation. You're all there in that small little neighborhood.
Yeah, it's temporary anyway. I need to get a job and then get my own spot. It's a temporary situation. And again, it was mainly just so that I could still be a dad. You can't be a dad sleeping outside,
Well,
So-
you can't be a dad showing up drunk and angry either, so you need to step it up.
Yeah.
All right, in the Kurt Coons case, this is one of two. I'm gonna order 17 days jail credit, 17 days. 0 fines at cost. Concur with Twyla Coons. Count. In the 2 of 2 with Twyla Coons, DV second. Were the kids there when this went down?
Yes.
They were in the house, but yes, they were within reason, yeah. They were.
All right, well, I'm sure they were frightened by this. I'm gonna, Twyla's case, I'm gonna order 30 days, credit 17. 30 days with good time is 25 days. You're gonna do a few more days in jail. Try to connect you with Lauren at Pivotal.
Thank you.
You're on probation for 12 months. Fine is 0. There's a $75 crime victims' rights fee and a $50 state minimum fee that I'm required to order. Gonna waive your attorney fee, not that Mr. Nausser didn't earn it, but you're gonna pay a probation oversight fee of $480. You're going to get no assaultive or threatening behavior, no drugs and alcohol, mental health treatment as directed, and take all meds as prescribed. Sign a release. No assaultive or threatening behavior, which this certainly would encompass. We're going to do drug and alcohol testing as directed. No drugs and no alcohol. We're going to just throw them right back in it. So I'm going to lay you out of jail in a few days, but you're going to be on probation. When you get out of jail, you need to come up here to the courthouse unless the probation department comes out to the jail and connects with you first.
Come to the Centerville court, because I know they were doing construction, so I'm just trying to be sure.
Yeah, it's Centerville Court. Actually, yeah, you come to the Centerville Court, where I am. You have enough insight to know that you're struggling. And some of this is just the stress of being unemployed.
It is.
Being.
It's the totality of everything, trying to balance
Yes, it is.
everything.
You're overwhelmed, but this just made it worse. But you're right, you need to get out, you need to align your waterfowl, and you need to get a job. And you need to stop this kind of stuff. It frightens your kids, it frightens their mother. So like I said, there's still the remainder of a year of jail hanging over your head. That won't solve the problem, but it will give everybody a temporary relief. At any rate, you're gonna get out in a couple of days. I'm gonna make a referral to Pivotal there at the jail, have her meet with you and see if they can at least get the process started. All right, you're good to go, sir.
Thank you, Your Honor.
Thank you, Judge.
All right, now we need to swap that out for our next customer,
Yes.
Mr. Reynolds. Good morning, sir.
Good morning.
This is Judge Middleton. I'm up at the courthouse with your lawyer, Mr. Luke Knopfsinger. Also present is Prosecuting Attorney Deborah Davis. This is the time set for a pre-exam conference in your case. I'm going to put you in an individual space with Mr. Knopfsinger so you can discuss your case privately. Title of the case is versus Skylar Jacob Reynolds, file 261425. You're charged with assault with intent to commit great bodily harm, larceny from the person, and interfering with a crime report. In the meantime, I'm going to set up this breakout room and you can talk privately with your lawyer, and I'll be here when you get back to see how we wish to proceed.
Okay.
All right, Mr. Reynolds, let's return to your matter. This is again Skylar Jacob Reynolds, file 261425FY. Mr. Reynolds is alleged to have committed several felony offenses. On July 19th, it's alleged that he did an assault upon Morgan Napier by strangulation or suffocation. That's a form of assault with intent to do great bodily harm, and it's punishable by up to 10 years imprisonment and a fine of up to $5,000. I also allege that you took a cell phone from Morgan Napier, and that would be charged as larceny from the person as a felony, punishable by up to 10 years imprisonment. You're also charged with interfering with a crime report, which is a 1-year misdemeanor. That has to do with taking the telephone away from her. And you're charged with being a second habitual offender, alleging that you had a felony conviction in the state of Ohio, making the assault charge punishable by up to 15 years imprisonment. Prosecutor Davis is here. Ms. Davis, there's a plea offer here.
Yes, Your Honor. The people would offer that if he pleads to a domestic violence second offense, we would dismiss the remainder. We have had contact by phone from the victim. We have not had a victim impact statement returned. She indicated she was going to return one. Not seen that.
Does he have a previous offense? Again, as you heard, I didn't have a criminal history in my file. So,
No, I don't have any prior domestic violence.
I believe it was a different charge that may fit under the statute.
it was a attempted robbery, could be aggravated domestic violence if you wanted a 1-year offense.
Is that acceptable? I mean, the intention was to have a 1-year max misdemeanor.
Well, the other twos, yes, that was the intention. Yes. I'm not quite, I think there was a bloody lip along. I don't know if that would be sufficient in terms of an aggravated.
It would be.
We do have pictures now. They were in the external documents. I can send them to you.
All right, well, let's discuss this. So they would dismiss all of these felony charges. Assault, great bodily harm by strangulation as a habitual, 15-year maximum, that would be dismissed. Larceny from the person as a habitual, 15-year maximum, that would be dismissed. Interfering with a crime report would be dismissed. Ms. Davis, would the people also forego resisting, obstructing for him hiding out in a bean field for 4 hours?
Yes, Your Honor, we have not received any charging requests for that. this point, we'd like to get this resolved so that he can deal with his Ohio parole.
He's on parole in Ohio
It's my understanding, yes.
He is judge.
from the 2016 case.
Yeah, he did several years in prison, remains on parole. He has a hold for that. The terms of his parole apparently didn't allow him to leave the state without permission, so it's important for the court to know that.
All right.
It's our understanding that he served 7 years and then was required to do a minimum of 5 years of parole. The parole is still pending or active, I should say.
Well, if he's been dating up here for several years, they may have been gone for a while. All right, anyway, Mr. Reynolds, this also would be a violation of your parole. Being convicted
Yes,
of a
sir.
crime while you're on parole is a violation of parole, even in Ohio. So that's part of it also. Do you understand that if you do plead to this charge, you will be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckee has been appointed to represent you.
Yes, sir.
Mr. Nossinger has been appointed to represent you. You could also hire an attorney of your own choosing if you wish. Apparently, we can't find a criminal history, but you guys have got one. So we'll sort that out. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And
Yes,
you
sir.
have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
Now, they've spelled your name Skyler and Skylar. Jenny, maybe that's why you can't find him. What's the correct spelling of your first name?
The E is correct, sir. ER.
Skyler.
Ohio always misspells it with an A though, so that could be where the confusion is.
All right, maybe you're under Skylar in Ohio. All right, anybody threaten you to get you to plead to this charge?
No, sir.
Or promise you anything other than this misdemeanor plea offer?
No, sir.
All right, this sounds like a bad night all the way around. Were you living out at Long Lake near Colon?
Yes, sir, I was.
And how long had you been there?
At the point that happened, I had probably been there for like approximately 6 months.
And were you in a relationship with Morgan Napier?
Yes, sir, I am.
Now, according to the affidavit of probable cause that's in here, you and she got into you assaulted her. And the police got called and they heard some of this. Then the cops got there and you took off out the back door. Did you, well, she says that you got into an argument and turned physical. And then she called the police and you tried to take the phone away from her. Did that happen?
Some of that happened. I didn't take her phone from her, no. The phone could have been lost during, like, we kind of wrestled around on the bed a little bit because she pulled a knife out and threatened to stab me with the knife. I have this video on my cell phone that's here where she threatened to stab me with the same knife. So,
right, well-
yeah, I did grab her down onto the bed, like kind of like tackled her down onto the bed and held her there. She could have mixed her phone up there, but I never physically
did
took her
you-
phone from her.
Did you put your hands over her nose and mouth?
No, sir.
Did you put some pop into her mouth to keep her from talking?
No, sir.
She said Skylar put pop into her mouth to restrict her breathing. You're saying that didn't happen?
No, sir, that did not happen at all.
Did she get a fat lip and a cut lip as a result of this?
She could have from, like, we were wrestling around on the bed a little bit. I took the knife from her and put it on the table, but I kind of tackled her onto the bed. So she could have got her mouth busted open from that.
So did she in fact call the police?
Not to my knowledge. I was told that a neighbor had called the police because we were arguing and like a noise complaint.
So did the police show up?
Yes, sir, they did.
And they came in the front door and you went out the back door?
Yes, sir.
Now, she says you guys have been dating for 4 years. Have you been in Michigan for 4 years?
No, I've been back and forth from Ohio to Michigan.
Okay.
But we have been dating for 4 years, though. That's correct.
All right. Throughout the assault, Morgan stated she would attempt to escape, but Skylar would grab her by the hair or leg or bring her back in the bedroom. He would hit her with an open hand or closed fist. He said he could kill her if he wanted to. That's her version. Your version is you were wrestling her on the bed and she may have got a split lip. I wasn't there. Ms. Davis, are you satisfied with the factual basis that has been presented?
I believe for the purposes of this being a domestic violence aggravated, that there was an injury. No weapon was used against the victim. He may make some other allegations and that's fine. But I think as far as a factual basis for his plea, we would be satisfied with that.
Mr. Knopfsinger, are you satisfied?
I believe there's a factual basis, yes, Judge.
All right. Defendant plead to aggravated DV. What would you like me to do here? Set it for sentencing or just proceed at this point?
Your Honor, under the circumstances, since we have had contact from the victim, we would ask that it be set out for sentencing.
Right.
He is still on the parole hold from Ohio, and I think that there needs to be a little more information, perhaps, for the court to review on those, and the option for the victim to give some input.
You got 15 days of jail credit. It's likely that the time I sentence you, I may give you time served and let you go back to Ohio and deal with your issues there. I think this matter is worse than you present it to be. You sound like the innocent victim in this. She says you're smacking her in the face, threatening to kill her. The truth is often somewhere in the middle, but I think it may be closer to her. Evidenced by the fact that you went out and hid in the cornfield for 4 hours. Cost hundreds of dollars of police resources, if not more. Let's find a date to put this, thousands maybe. You're here for Dylan Penn on Thursday, August 27th in the afternoon.
Yes.
How about if we set this for 3 o'clock, August 27th?
I can make that work, yes.
Mr. Reynolds, that's farther out than I really wanted to do it. But I'll get the police report and victim input. It will also give them the opportunity to connect with the Ohio authorities and let them know what their intentions are.
Okay.
All right. This matter is continued for sentencing for 3 p.m. Sometimes we have to be flexible to make things fit, that time should work. I will see you at that time. You'll probably be brought up here live to the courthouse.
Okay.
All right, sir. You're good to go. Thank you.
Thank you, Your Honor.
Thank you, Judge.
And thank you for being here with us tonight and hanging out and chat. It's been an amazing chat. What can I say? What can I say? Wixom, you go see Judge Middleton. Tell him thank you very much from the Lone Wolf Usul. We learned so much watching his court. I hope Tim George carries on so we can all continue learning, and maybe, just maybe, Judge Middleton might like to watch some of the cases himself. Who knows? Probably not. That's probably just crazy talk. In any case, I do want to say a big special thank you to Darth, Steven, Miss Good Kitty, OX9DC, and Barry Adams. Barry Adams, crazy man. Thank you so very much. Struggle Bus passes to the totality of everything to align your water bottle. Those are the words of the night, ladies and gentlemen. I have no clue what any of them mean, but they are absolutely words, and I appreciate every single one of them. You know what else I appreciate? All these names on the screen right here. See all these names? I appreciate all these names. Every single one of them. All you folks. Thank you so much for hanging out with me tonight. I do this every single night of the week, 8 p.m. Central Time, 9 p.m. Eastern Time, where I find a bunch of court cases from the day, today. All of these were from today. And yeah, we watch them, we review them. We see what's, oh, Steven, thank you so much. Darth Steven coming in with a late super chat there. Well, it's not late. An amazing super chat there. What am I saying? I don't know what I'm saying. I'm covering up the amazing music. I shouldn't do that. Look, there's that super chat. Right there. Thank you all for hanging out with me. It's been so much fun. It's been great seeing all you here. We've had OSG here tonight. We had KFAR dropping by tonight. I think I saw somebody else. Oh yeah, Dan, TCF, all the crew at TCF. Thank all you people for coming by too. I was actually hanging out with them at TCF and chatting before I started this. I have to admit, I'm a sick wolf like that. I quite often go to other people's channels and just kind of hang out, lurk, maybe chat every once in a while. Thank you so very much, Becky, for all the kind words. Thank you all for the kind words. I do this every single day of the week, and I will be doing it again tomorrow. Same wolf time, same wolf channel. I am your Lone Wolf Usul. I am your humble curator for this here archive of online court interesting cases. I'm your humble host for this daily get-together where we have a little bit of a forum and discuss cases of the day. And for now, I am out. No, I don't pee on the flowers. And remember, only you can take a bite out of crime. Bye!